On this morning's Ag Issues program, a pleasure, as always, to bring on to the program Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law. He joins us this morning. Roger, good morning. How are you?
Good morning, Greg. Doing fine, thanks.
Well, we got an interesting topic to discuss, and this came from your recent blog, but it's a good start to the of our discussion. And you just posed the question: is your farm or ranch protected from a warrantless search? And this is with regards to the Fourth Amendment and the protections that the Fourth Amendment provides.
Yeah, and the answer to the question is going to surprise probably a lot of farmers and ranchers, and the answer is basically no, it's not. The Fourth Amendment does protect against illegal searches and seizures, but to what extent? Of course, the provision says you're provided protection to your person, your house, your papers, and effects. Well, the question for us in ag is, does that extend to all the open areas that you own? You may have a section of land that's a mile square. Are you protected in all of that, or can government officials basically trespass onto your property, even if it's posted no trespassing, and search the property, set up cameras, monitor your conduct, all without gathering probable cause and going to a judge and getting a warrant? And there have been some pretty egregious cases on that. And in fact, the Kansas legislature just this session passed a bill. The governor signed it into law, trying to deal with this issue. And we'll get to that in a little bit. But basically, going back almost 100 years, the U.S. Supreme Court came up with this legal term known as curtilage. And they said basically that's the area that immediately surrounds the home. And you're safe from a warrantless search in that area, but when you get beyond that, then the Fourth Amendment doesn't apply. And so the question for us in ag is, well, how far does that extend beyond my residence? The yard, outbuildings, those types of things might be within the curtilage of the home as an immediately surrounding area, but you get out into fields and forests and ponds, away from the house, forget about it. You're not going to have any protection under the Fourth Amendment from a warrantless search.
And this really, and you talk about that case, or several cases itself, but there are several, I'm sure, numerous situations that has come up, that has ended up in the courts as far as, curtilage and what is considered that, or situations, and because agriculture is not the same everywhere in this case.
Yeah, and the Supreme Court is known to come up with multi-factor tests. They like balancing tests, multi-factor tests. I've always kind of been critical of that because all that does is lead to more cases where we have to figure out whether you satisfied the test. Very rarely in the law do they lay out black and white. Once you cross a line, that is, you're in violation, or if you haven't crossed the line, that's not, we don't deal much in the law with black and white. We deal with a lot of gray. And indeed, the U.S. Supreme Court back in 1987 came up with a set of factors for determining what constitutes curtilage. And as you indicated, it's going to vary from case to case. And they look at the nature and the use to which an area is put, what are the steps, if any, that the resident of the home took to protect the area from observation by passersby. And those are the primary factors in this case that came out of this case back in 1987. And then subsequent court opinions, of course, have dealt with applying those factors. And we had an important case, again. This came from the Ninth Circuit, which is out in the western part of the United States, and that kind of turned the curtilage issue on its head. And the court said that all the evidence that was seized from a shed in that instance was to be suppressed because the shed was not within the curtilage of the residence for which a search warrant had been issued. The warrant had been issued for searching the home. It didn't pick up a shed. And the court said that the home and the shed were not enclosed by a fence or a natural boundary. There was no evidence that the shed was used for illegal activities. And the defendant didn't take any steps to prevent the observation of the shed from passersby. And that kind of turned that curtilage issue on its head. So that one's kind of out there a little bit different. And the U.S. Supreme Court actually declined to hear that case. But there was a Florida case back in 2007, and there they allowed a warrantless search of a greenhouse because it was not within the curtilage of the defendant's home. It was used to manufacture controlled substances. It wasn't locked. It was made of semi-transparent material, so you could kind of see through the structure to see what was going on inside. And so the court said, well, the owner didn't really have any reasonable expectation of privacy with respect to that greenhouse, and so it wasn't protected against an illegal search. And then we've just had a number of cases dating back, 2012, even going back into 1999, with respect to ag cases, all the way up through. And basically, they've said, your ag property, what's known as the open fields doctrine applies. That's an exception to the requirement to get a search under the Fourth Amendment. So these can be searched, these open fields can be searched without a warrant. And then we just got a couple of egregious cases. The most illustrative of those was Tennessee, federal court case in Tennessee in 2019. And that one was an absolute mess. And that's the case in 2019 that really has set ag on it, has given ag a big warning sign that, hey, you've got to pay attention to this, and state legislatures may need to react to this if they want to put in greater protections in their own state law or amend their state constitutions to provide farmers and ranchers, agricultural producers, rural landowners from warrantless searches. And that Tennessee case was just absolutely awful based on the facts.
Yeah, the information you sent me on that, I had to read it 2 or 3 times just to absorb how
it's hard to believe what happened. Yeah.
Oh my God, yes. You might want to explain, or I guess set the boundaries here as to what the situation was, because then it's the mind blown type of case and or the situation that occurred.
Well, yeah, you've got a fellow who's got farmland in Tennessee, and of course Tennessee's much of it is hilly and full of trees and so forth. So he's in his pickup truck one morning. He's going out to hunt ducks on his property. He's got some wet areas and some ponds, and so he's on an interior lane in his pickup truck before daybreak, heading to a duck blind on his property. So he's not crossing anybody else's property. He's on the interior of his farm. Not an exterior lane. He's kind of going down an interior lane, and he comes around a corner, and his pickup truck headlights catch a reflection up in the trees. And he thought, well, that's interesting. I've never noticed anything there before. So he stops and gets out, takes his flashlight, shines it up in the tree, and he sees a camera that's zip-tied to a couple trees. And so he gets up there and cuts it down, and it's got an antenna on it, the receiver, it's got a SIM card in it. So he throws it in the pickup truck and goes duck hunting, and gets later in the day back up at the house. He pulls that card out of there, and it's got over 1,000 pictures on it of he and his family over the past several months. And it also identifies a couple of officials with the state of Tennessee, one of them is a U.S. Fish and Wildlife Service. One of them is with the Game Department in Tennessee. And so, long story short, a few days later, the government officials stormtroop his house with guns drawn to get their camera back. And so he sues, and he said, well, wait a minute. You didn't have any business being on my property in the first place. I had no trespassing signs up on my perimeter. You had to cross 2 fences to get to where you zip-tied these cameras in the tree. So you were trespassing at the time you did this. You know that this was posted property. And then you stormtrooped my house with guns drawn. You didn't have a warrant for any of this stuff. And he sued him. And the court said, that's fine. Open fields doctrine applies. You didn't have any expectation of privacy on your farm property. And that really has irritated a lot of people in ag. I think a lot of people didn't realize the Fourth Amendment is so limited by this open fields doctrine that they are not secure in their farm property. And so there's no requirement in these situations for government officials to go get a warrant. And the court said, well, trespass law really doesn't apply with respect to the Fourth Amendment. And so you can't sue based on trespass either.
And what was it? Part of the argument was, well, like you said, it was zip tied to a tree, but he was trying to make it comparable to a tracking device, say, on the underbody of an automobile, which I don't think is legal, if I'm not mistaken.
Yeah, you can't do that. You have to have a warrant to do that. And that's the analogy he was trying to make. That didn't work because an automobile is an effect, and that's the key word that's used with respect to the Fourth Amendment. It's a personal effect. And so the government can't attach some type of tracking device to a personal effect like that. Now, farmland is not a personal effect, and so that's how they distinguish that. That's not intimately associated with you. That's out in the open. That's a half mile from your house or a mile from your house, whatever the case might be. That's not a personal effect, and so that's how that argument did not work.
And the court, like you said, looking at it, allowed what was going on as well. But this is where you think you have everything right. You've got no trespassing up, going through that as well. Yet, here's what's happened, and yet, here's what the decision is, too.
Yeah, and the federal agent from U.S. FWS in this one claimed sovereignty on this one, and the landowner gave that argument up. It's pretty hard to sue a federal government official because they do have that sovereign immunity claim that they could raise, and so he conceded that claim, but he asserted that the open fields doctrine didn't apply because, again, these government agents had to pass through two gates and fences to reach the interior of his property, and the exterior was posted with no trespassing. The court said doesn't matter. Open fields doctrine applies. That's an exception to the requirement of the government to get a warrant to search your property.
Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, is joining us on the program, and we have been talking about, as he put it in a recent blog, is your farm or a ranch protected from a warrantless search? And Roger, we've been talking about the cases, and you had mentioned that states will need to look at this issue as well, and Kansas did just that. As a matter of fact, Governor Kelly, back on the 18th of last month, signed HB 2299. It goes into effect July 1st, the start of the new fiscal year, and I'll state, bars any employee of the Kansas Department of Wildlife and Parks from conducting unauthorized, quote, surveillance, end quote, on private property without a warrant, court order, or subpoena. But I know you have looked and have some concerns about what that new law entails.
Period right there, that would have been very helpful, but they didn't stop. They went on to include exceptions to the warrantless search issue, and they said that unless, okay, here's where you get to unless. This means, okay, you can search it without a warrant. Now get this, unless the search is authorized pursuant to the Constitution of the United States, end quote. What have we just spent the last 20 minutes talking about? How the Constitution allows warrantless searches under the open fields doctrine on farm and ranch land. They put in what I would call a self-neutering provision. They just neutered the whole statute right there. That will do absolutely nothing. That provides no greater protection than where we've been at in Kansas. For the life of me, I don't understand why they did that. Maybe it's just they don't understand the 100 years of case law on this, but that does nothing to limit the open fields doctrine being applied to farmers and ranchers in this state. I understand what they're trying to do. It's a reaction to what happened in Tennessee, and that's good to try to put more protection in state law. But then when you say a warrantless search is authorized if it's consistent with the U.S. Constitution, well, then you bring back in the open fields doctrine, and you've done absolutely nothing in your statute. That's unfortunate.
So in this case, the same thing that happened in Tennessee could happen in Kansas if it goes to court. What you're saying is no case in this case.
Yeah, absolutely. The landowner is going to face the same result as the landowner in Tennessee did, because the legislation says unless it's authorized by the Constitution. Well, the Constitution authorizes the open fields doctrine. That's the way it's been construed for 100 years. So again, I don't know why they put that in there. Maybe it was to get it passed, but it doesn't do anything. So we shall see. But you know, the thing that really gripes, I'll go back to that Tennessee case, the thing that really gripes, and legitimately so, farmers and ranchers, is when I post my property as no trespassing, that is an express intent that I want privacy. That I'm expressly manifesting my intent to have privacy on my property. So if the government wants entry into an area that's posted no trespassing, then I think a reasonable reading of the Constitution requires them to go get your probable cause, go get a search warrant before entering. It's as simple as that. But this is a problem that farmers and ranchers face. The Fourth Amendment does provide greater protection for people that live in town that don't have large tracts of land than it does for those rural landowners with those tracts.
One question in my head, and going back to this Tennessee case, was it ever said or was it ever asked of the U.S. Fish and Wildlife officials why they had that camera up, in this case, in that tree?
Well, I'm sure it was. It's not really revealed in the case. Sometimes when you read court opinions, you're just dealing with the issues directly presented to the court. Sometimes on appeal, they don't even get into a lot of the facts. Well, I'm sure it was. It's not disclosed in the court case what they were looking for. But my suspicion is improper hunting of migratory waterfowl under the Migratory Bird Treaty Act is probably what was going on. Illegal baiting of birds, that type of conduct. But I don't know. That's just surmise on my point.
All right, sounds good. And Roger, by the way, if anyone wants to read this blog, and it's a great read for anyone who's interested in reading that, what's the best way they can find that?
Off my website, and that's washburnlaw.edu/Walter, WALTR, and then down the homepage on the left side, you'll see the link to the Agricultural Law and Taxation blog. It's part of the Law Professors Blog Network. And there's even another link where they can click on that to get an email notification every time I post something on there.
All right, sounds good. Well, Roger, as always, appreciate it, and thanks. We'll talk to you in a couple of weeks.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the Ag Issues program here on 580 WIBW. All right, stay with us. When we come back, we will get an update on the news headlines, and we'll check the weather forecast. That comes up next.